Case briefed by Abigail Prado and Stephen Corona. Aquarian Foundation, Inc. v. Sholom House, Inc. 1983. District Court of Appeal of Florida, 4th District. Citation 435. So, 2D 549. L.A. Dist. CT App. 1983. In a quiet city in Florida stood a well-kept condominium complex called Sholom House. The community was peaceful, orderly, and tightly governed by a group of board members who took pride in maintaining strict control over who could buy, sell. Every sale or transfer required the board's written consent, and they reserved the right to deny approval arbitrarily, capriciously, or unreasonably. Among the board members was Bertha Alvarez, a longtime resident who knew the rules well. But one day, Bertha sold her unit to Aquarian Foundation, Inc. without asking for written approval from the board, a direct violation of the condominium declaration. When the board discovered the sale, they were furious. To them, Bertha had not only broken the rules but also betrayed their trust. They immediately filed a lawsuit against Bertha and the Aquarian Foundation to 1. Void the sale completely. 2. Eject Aquarian Foundation from the property. And 3. Enforce a reverter clause, a rule that said if a sale occurred without permission, ownership would automatically return to the association in exchange for paying the owner fair market value. At trial, the court sided with Sholom House, ordered Aquarian Foundation out, and said it would later determine the property's value and damages. But the victory was short-lived. Aquarian Foundation appealed. On appeal, Aquarian Foundation argued that the condominium declaration gave the board unlimited power to stop anyone from selling their property. They claimed this was against public policy and violated a basic constitutional principle, the right to freely own and transfer property. Even though the association offered to pay fair market value through the reverter clause, Aquarian Foundation argued that money could not justify such an unreasonable restriction on ownership. It was on appeal. 1. Was it lawful for a condominium board to have the power to arbitrarily or unreasonably deny consent to a sale? 2. Did offering fair market value compensation through a reverter clause make that restriction reasonable? Aquarian Foundation, defendant appellant, argued that 1. Rule gave the board total control over sales, effectively destroying an owner's right to transfer property. 2. Florida law allows restrictions on property transfer only when they are reasonable and serve a legitimate purpose. 3. This restriction was absolute, with no standards or fair process, violating public policy. 4. The reverter clause didn't fix the problem. Even if the owner was compensated, they were still being forced to surrender their property without cause. Sholom House plaintiff appellee argued that 1. Condominium living requires rules to preserve community stability and property. 2. Every owner voluntarily agrees to these restrictions upon purchase. 3. The reverter clause was fair because it ensured the owner received fair market value, avoiding any financial loss. Court's analysis. The appellate court examined the condominium declaration closely, giving the board the right to deny approval arbitrarily, capriciously, or unreasonably, amounted to absolute discretion, a complete block on an owner's right to sell or transfer property. The judges explained that while some restrictions are valid, such as verifying a buyer's financial qualifications or maintaining community standards, be reasonable, purposeful, and non-arbitrary. The Sholom House rule failed this test. It allowed denials for any reason or none at all, providing no guidelines or safeguards. The court labeled this an unreasonable restraint on alienation, a legal term meaning an improper restriction on the right to property. The reverter clause did not cure the problem. Paying fair market value couldn't justify depriving someone of their essential property right. Ownership means the freedom to sell, not merely to be compensated after being forced to give it up. As a result, the appellate the trial court's ruling. It held that a condominium declaration allowing a board to arbitrarily, capriciously, or unreasonably deny sales was invalid and unenforceable, even if it included a reverter clause. The sale to Aquarian Foundation was upheld, and the association's restrictions were struck down. The court reasoned that the association's rule was an absolute restraint on property transfer and violated public policy. And condominium ownership does not strip away fundamental property rights. Restrictions must be reasonable, clearly defined, and based on legitimate purposes, not on permission. And compensation does not make an unreasonable restriction lawful. Therefore, the appellate court ruled in favor of Aquarian Foundation, Inc. The attempted reversion of the unit to Sholom House failed, and the association was required to amend its declaration to comply with Florida law. This case became a landmark decision in Florida property law, setting a precedent that condominium boards cannot hold unlimited power over property transfers. While rules can exist to protect communities, they must never destroy the fundamental right to own and transfer property. The case reminded associations that they are meant to govern, not dominate. And the key takeaways: a restraint on alienation, the right to sell or transfer property, must always be reasonable and limited, and condominium boards cannot act arbitrarily or unreasonably. And compensation clauses, like reverter provisions, do not make unreasonable restrictions. One, property ownership includes the essential right to sell or transfer. In Aquarian Foundation, Sholom House 1983 stands as a warning that freedom of ownership outweighs